Speaking of materiality, guess who has the fraud is just fine because the government's in on it defense?
Oh, hold on one second. Darn it, Robert. I know it. I know it. It was, I need a hint.
It's one of my cases.
Oh my goodness, the FDA, Robert. Let's go. Sorry, no, it was Pfizer. It was Pfizer. Sorry.
So we were in court this week scheduling as.
Hold on a sec. Disclaimer. This is not legal advice. This is not medical advice. This is breaking down current pending lawsuits of national, international, and historical import. Robert, please go ahead and break it down.
So I represent Brook Jackson, who is a whistleblower who exposed that the Pfizer clinical trials were riddled not only with error, but with fraudulent and false certifications to the U.S. government. That's the allegation of the suit.
Allegedly.
Yes. Well, she's got a lot of evidence of it. But what's fascinating is Pfizer has moved to dismiss the case. And their grounds to dismiss, as they repeated in the scheduling conference we had this week, is that it doesn't matter if they submitted fraudulent certifications to the government. It doesn't matter if they submitted false statements under penalty of perjury to the government. It doesn't matter if they lied about the safety and efficacy of these drugs mislabeled, in my opinion, as vaccines, because the government was in on it with them. The government knows what's going on, and the government still would have given them the check anyway. So is it really fraud if the government's their co-conspirator? That is, in essence, Pfizer's defense so far to the case. So it'll be an interesting case. The judge said that we would be entitled to discovery about any issue related to the motion to dismiss. And so that covers some territory.
That's an interesting thing. In Quebec, last time I checked, if you make a motion, anytime you file a new affidavit in support of a motion, you get to examine on the affidavit. So if they filed a motion to dismiss, basically saying, look, we're innocent, but even if we're guilty, they authorized us to do it. Do you not get to examine them on those new allegations, which were not part of the original proceeding and are new to the file? So
that's what the judge said. Judge said we're entitled to discovery on those issues, which they were going ballistic about. They kept saying, "Oh, well, we've just moved to dismiss. Motion to dismiss is on the four corners of the pleadings." Not their motion to dismiss. Well, their motion to dismiss includes a bunch of extra extrinsic information, documentation, and testimony, which we're absolutely entitled to contest and dispute and to get discovery concerning. So the court recognized the same. Very straightforward, old school judge. He was talking about when he first saw some federal rules, he thought that they were communist back in the day, 30, 35 years ago, but he goes, they really work well. And it involves, disclosure and discovery in a timely material way. So they'll be able to limit some discovery, but not as much as I think they wanted to. And it was a fascinating defense to say, yeah, maybe we lied, but even if we did, it doesn't matter because some high-ranking government people were in on the lie. I don't think that's going to be a defense the court's ultimately going to buy, but it entitles us to discovery in the interim. So it's going to be Brook Jackson's case marches onward. Probably the biggest whistleblower False Claims Act maybe in the history of the United States.
And I don't want to overblow this, Robert, but people have to appreciate how important discovery is even on a motion to dismiss. Now, in the practice, people, if you make a motion to dismiss and you say this should be dismissed, even assuming the allegations of the original claim are true, that's far different than saying it should be dismissed because of this, this, and this. Because if you file new exhibits, make new allegations, which are not within the four corners of the lawsuit, you expose yourself to examination on those elements, on the affidavit of the new facts, which were not part of the court file. It may be limited to the motion to dismiss. That's going to be fun. So this really is actually a big deal, Robert.
Oh, huge. Absolutely. I mean, the goal of Pfizer, they had however many lawyers there. There's one lawyer after the other. Just lots and lots of corporate lawyers. And that was just the ones present in court. Then there are a bunch more on the phone and all that jazz. And I'm sure a bunch more listening in. Because that kind of case. But it's huge. I mean, their goal was for this case to go away right away and for them not to have to disclose a single piece of information, a single piece of documentation, and just for them to be able to walk out without any consequence, because too often that has happened with big drug companies in America. This concerns Pfizer stealing $2 billion. That's the allegation, $2 billion from the people of the United States, which they're trying to confuse. They're saying, oh, if the government chooses to intervene, that's what governs the case. It's like, no, this claim is brought by Brook Jackson on behalf of all the people. Sometimes the government does a good job of advocating for the people. Sometimes it doesn't. Either way, that's whose interest is at stake. Did Pfizer make false statements that got them a $2 billion check that they were not entitled to if they had made truthful statements?
I love it, brother. You say stealing it tongue in cheek, and I'll just say it's one or the other. It's a theft or it's a gift, both of which are equally corrupt under the circumstances.
I mean, it's something that the people should not have had to write a check for. They were entitled to honest representations by Pfizer, and the allegations of the suit and the evidence presented by Brook Jackson dispute that.